The Chair of the Commercial and Administrative Law Subcommittee, Ms. Sanchez.
The gentlewoman from California is recognized for 2 minutes.
Thank you, Madam Speaker. We have reluctantly reached today's vote to hold former White House Counsel Harriet Miers and White House Chief of Staff Joshua Bolten in contempt of Congress. Since March 9th of 2007, Chairman Conyers and I have patiently negotiated in good faith to reach an accommodation with the White House for documents and testimony relevant to the U.S. Attorney investigation. Unfortunately, under normal instances I would, but I don't have the time, and I apologize.
On the floor so that on my time I'll be able to move to her
I
and have a
apologize to the gentleman, but this is my time.
Gentlelady will suspend.
We've patiently negotiated in good faith to reach an accommodation with the White House for documents and testimony relevant to the U.S. Attorney investigation. Unfortunately, the White House has stubbornly refused to move off its opening position, an unreasonable offer that testimony be given without an oath or a transcript, and that any testimony and documents provided exclude internal White House communications. To have negotiations, concessions by both sides are necessary, otherwise it's just capitulation. I was extremely disappointed that Ms. Miers, Mr. Bolten, and the White House based their refusal to comply with our subpoenas on sweeping claims of executive privilege and immunity that some experts have called Nixonian in breadth. The subcommittee carefully considered these claims in 2 separate meetings last year, and in detailed rulings I found that these claims were not properly asserted and were not legally valid. Even if the claims were properly asserted and legally valid, the strong public need for information about the U.S. Attorney firings substantially outweighs the assertion of executive privilege here. I was also very disappointed to hear from Attorney General Mukasey in testimony before the Judiciary Committee last week that he will direct the D.C. U.S. Attorney not to comply with the contempt statute, which provides that the U.S. Attorney shall refer the contempt citation to a grand jury for action after receiving it from the Speaker. Members on both sides of the aisle should recognize the gravity of this vote. If the executive branch is allowed to simply ignore congressional subpoenas while Congress idly stands by, we will have abdicated our role of oversight of the executive branch and undermined our system of checks and balances.
This time has expired.
I would ask for an additional 20 seconds.
I will yield the gentlewoman 30 seconds.
Gentleman is recognized.
I thank the gentlelady from New York. Furthermore, our lack of action will be cited by future as justification for questionable claims of executive privilege. I hope that my colleagues on the other side will stand together in support of this body's institutional prerogatives. Time is long overdue for Congress to reassert itself as a co-equal branch of government. I urge support of the rule and House Resolution 979 and 980, and I yield back the balance of my time.
Gentleman yields.